Board. Ms. Vest, will you please call the roll?
Thank you. Scott Cockcroft.
Here.
Lou Richard.
Here.
Vivian Hickson.
Here.
Doug Fraker.
Here.
Keith Harvey.
Here.
You have a quorum, Madam Chair.
Okay, thank you. Next, have the members had an opportunity to review the agenda for today's meeting, and if so, a motion to adopt?
Make a motion to adopt the agenda as presented.
Second.
Okay, we have a motion by Mr. Fraker and a second by Mr. Cockcroft to adopt our agenda as presented. All in favor, voice by saying aye.
Aye.
All opposed? The agenda is adopted. Next, the members were presented with the minutes from the June the 20th, 2019, and the August 22nd, 2019 board meetings. Have you had an opportunity to review, and if so, a motion to approve these?
Make a motion to approve both meetings minutes as presented. Second.
Okay, we have a motion by Mr. Cockcroft, a second by Mr. Richard to approve the minutes from the two previous meetings. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Mr. Gentry, the legal report.
Good morning. We'll start with number 1, 2019-056491. The summary is the complainant entered into a 3-year contract with the respondent in June 2014 to provide monitoring services. Complainant stated that she had never been contacted by respondent about upgrading equipment or renewing her contract, so in November 2018, complainant decided to enter into a monitoring contract with another company and to cancel her contract with the respondent. Respondent told complainant that if she canceled her services, she would owe an early termination fee, as there were still 18 months left on the contract. Respondent stated that it had entered into a revised contract with complainant in April 2018 that altered the services provided by respondent and extended the term of the contract by another 36 months. Respondent stated that the contract contained an early termination fee provision and that complainant was aware of this early termination fee, as she told respondent that the new monitoring company had agreed to pay the early termination fee. Respondent is not willing to waive the early termination fee and stated it will adhere to the terms of the contract. Copies of the contract and the subsequent addendum were obtained, and the early termination fee was in the contract, and it did not appear the complainant was being charged anything above what was agreed upon in the contract, so the recommendation is to close.
Make a motion to concur with recommendations of our council, as this is a civil matter.
Second.
Okay, we have a motion by Mr. Cockcroft and a second by Mr. Harvey to concur with our council's recommendation in this. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Number 2, 2019-066731. The summary is that the complainant entered into a 36-month contract with the respondent in January 2016. Complainant stated that his ex-fiancée extended the contract and complainant can no longer afford it. When complainant called to cancel his contract, he was told there would be an early termination fee. Respondent responded to the complaint and agreed to terminate the contract and waive the early termination fee. The recommendation is to close.
Make a motion to concur with council's decision.
Second.
We have a motion by Mr. Harvey, a second by Mr. Cockcroft to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 3, 2019-068871. The summary is this is an industry complaint that alleged a respondent was advertising and performing services as an alarm systems contractor without a license. Specifically, complainant stated that respondent manufactures cameras and sells them directly to customers, and that the cameras are used to take pictures of license plates on vehicles that drive past the cameras. The respondent manufactures the cameras and the software used in the cameras so that once installed, the cameras have a motion detection system that will take a picture of a vehicle's license plate and catalog the information on the plate and vehicle. Respondent disputes that the cameras are considered an alarm system, as the cameras are not monitored in live action, and stated it takes time for the pictures taken by the cameras to be uploaded and viewable into the camera's cloud system. The cameras are designed to store information on vehicles that move through a certain area so that this information can be stored for later use. Respondent states that the cameras do not detect, prevent, or record any intrusion on property loss, as the cameras do not take pictures of any crime in progress, but rather take pictures of each vehicle that passes through an area decided by the customer. The respondent states that it also does not sell the cameras to the customers, rather it leases the cameras to the customer and sells them the software access to allow the customer to access the data captured by the cameras. Respondent does not perform any monitoring services, and all images and information captured by the cameras are only accessible by the customer or the customer's designees. Once the camera is operating, respondent no longer has access to the camera, its software, or the data collected. Respondent further stated it does not do any installation of the cameras, and that installation is done by the customers or licensed contractors to perform the installation. Respondent does not have a license and stated it should not need one as it's not an alarm systems contractor, and its cameras are not part of an. Respondent further argued that it's exempt from as a manufacturer since it leases the cameras and does not sell them to the end user. The recommendation for this one is to set it for discussion. Based on it's more of a technology issue that I thought the board should better decide as to whether or not this actually meets the definition of an alarm system. Looking at the statute, we're looking at whether or not it records, views, or monitors, or protects against, avoids or reduces the probability of any personal or property loss or injury resulting from fire, smoke, heat, burglary, theft, shoplifting, pilferage, or other loss of that type, or if it monitors, detects, or prevents intrusion, or detects and summon aids for other emergencies. And based on the definition, it's kind of loose here as to whether or not that fits that, so I wanted to present that to the board.
The definition you read was what's in the...
It's in the statute. Mm-hmm.
But it also, does it reference CCTV separately, or does it lump it all in? I can't remember off the top of my head.
When we look for the requirement of whether or not you need a license as an alarm systems contractor, it talks about whether or not you're monitoring or you're selling an alarm system. And I believe CCTV is bumped into that, but there is a separate definition for that.
A lot of people seem to get hung up on that it's getting thrown in called an alarm system. And I get that a camera is not, quote, an alarm system. I think it has to do with the way the statute's written. That's usually everyone's defense is it's not an alarm system, but the way the statute's written is that it includes it in, not as the typical definition dictionary, but... You looked at their marketing information, who this company is.
I have.
Do they maintain in their marketing the same thing that they say here, that it doesn't detect or deter or do any of these things?
And that's part of the issue. When I talked to counsel on this one, the marketing. There's a lot of marketing for this company. Actually, they have a very aggressive media campaign. It seems like, and a lot of it kind of capitalizes on this idea that it is deterring crime, or that it's capturing crime for for an HOA or another user to pick up and to kind of solve their own crimes. It doesn't specifically say we're not an alarm system or we don't do anything. It does. If you go in a little bit deeper on their website, it talks a little bit about the specifics of, this records the pictures of every single license plate that drives by. It catalogs it for you. You can decide who goes in and looks at it. It's not shared with the police. So you can decide, what you want to do with that information, if you want to give other people access to it. But it doesn't specifically... Some of it, which looks like it's more by third parties, it talks more about how it prevents crime. What they specific say doesn't... or what they're specifically marketing on the website doesn't specifically say this is aimed to do that, but it talks about how it can do that, if that makes sense.
They say it doesn't, their statement is that it doesn't detect or deter, is that correct? And they're saying it doesn't detect, meaning it doesn't detect and summons help immediately, but that doesn't mean it doesn't detect. It could still be detecting crime and recording crime, because even an alarm company installing a local alarm that's not monitored has to be licensed.
Right.
If there's an alarm contact on a building and the door's open and the siren goes off, but it doesn't necessarily immediately summon somebody, that doesn't not make it not an alarm. It's kind of like if a tree falls in the forest, it's still going to make a noise.
Yes. And I think, when we're looking at the alarms that go on doors or windows, right. I think that fits more under B, where it detects or prevents intrusion. And we're talking about here, it's not necessarily preventing that intrusion. That that person is still driving down that road and it takes a picture of every single license plate. So I think what they're saying, that it's not monitoring crime or detecting crime, is that because it does every single camera. But I agree, any other camera that's sitting there is going to record everything that occurs. So I think when we look at alarms, we're looking more under that 1B of, does it prevent intrusion? If we're looking at CCTV, it's typically looking more under A or C, depending if it's live monitor or live monitoring.
Most CCTV products are not live monitored anymore. 25, 30 years ago, yes, you had some guy sitting in the guard shack watching. But the law didn't change. You still have to be licensed to do CCTV work.
I think the only distinction between traditional CCTV and this would be that with CCTV, you are recording everything that occurs in that area, and with this, or the customer is just getting the license plates. So it's not necessarily right. And I know it's a minor distinction, but I do think that it's something that the board should consider. When I look at it, I could kind of see it going either way in candor, because I see it as a situation where if you're just picking up those license plates, you're only seeing who's going through that area, and then you're making that next step to say, okay, well, we knew that vehicle was used in this crime or was used in this capacity.
Any provisions that exclude a manufacturer even though the manufacturer is installing the equipment?
Well, they're not installing.
Right. The manufacturer's exemption is as long as they're not selling it. So traditionally, if a manufacturer is making cameras and they're selling to the big box stores, the big box store is the one who's selling to the customer. Here, they're trying to make that distinction by saying, because the statute says, as the manufacturer, are you selling them? And they're saying, well, we don't sell, we lease, which isn't a major distinction. I think that's something that when you look at, we don't define what's a sale in our statutes.
I like saying I didn't pay cash, I paid with my credit card.
Right. Well, we're looking at it too.
Is it not covered anywhere? Is it all in the statute? Does it all say sales? It doesn't say sale or lease?
It says for the manufacturer's exemption, it says sale. For the other prohibited practices, it talks about no alarm systems contractor. Where was it? Talks about no person shall sell and install, no person. And there's another one that talks about sale. We only use sale. The only time we talk about lease in our statutes is when we talk about an exemption for if you're owning lease documents, talking about if you're just holding, the leases, I guess, for equipment that, someone's monitoring through.
How do we define, is there a definition of sales in the statute?
Not in our statutes. The closest thing that I found was under Black's Law Dictionary, which is what we typically use when there's not something on point. It just talks about whether or not there's a transfer of rights. Arguably, leasing is also a transfer of rights. You hold certain rights as a lessor when you're as a lessee.
I guess even aside from the camera, they could lease the camera, but they're still selling the service of storing the information and gathering the information. They're at least selling that.
And I think, well, and that's why I think that they're saying that the exemption would be because if the software itself, if that's the only thing that they're selling, if they're saying that's the cloud access that then, picks up on these things and is able to, I guess, decipher and say, okay, here was a red car with this license plate and say how many times it drove through. That's what they're saying that they're selling. And that software itself may not meet the definition or our definition of an alarm system. I think the software itself, what it's designed to do, is probably not something that would fit that definition when used with that camera as well. That's when we're looking at whether or not it's the alarm system.
I guess to me, the thing is they're going straight to the end user. And call it a lease, call it a sale, whatever term you want to call it. You know, even in alarm systems, you write 3-year contracts and you're leasing your equipment, but at the end of this 3 years, you own the equipment, that kind of deal. That's out there all the time. To me, this is basically the same thing. We don't know if they're signing any kind of contract. But
My opinion, honestly, if they were just leasing the camera, you know, if they were manufacturing an NVR and a camera, and they were leasing just the equipment, they were going to ship it to the customer customer's going to either put it in or have a licensed contractor put it in, I don't think they would require licensure. It's the other portion of it, the cloud storage and the service that they're offering. It seems like there's more to this than maybe that's being brought forth here in this response as far as, I mean, if it's truly just all it's doing is cataloging license plate numbers, but it does say that, you know, the pictures are available for people to see. It's like there's other stuff going on here that's not explained.
Well, I'm sure there's design involved in this too. I mean, there's got to be.
I guess one thing to add, talking
That's
about
a good
the
point.
lease or the sale, it doesn't say on the the website as well. I don't know if that matters greatly, but I know that wasn't included. The website doesn't necessarily say, you're leasing these equipment. It makes it sound like you're entering into a contract to buy it. That was specifically from their response from their attorney saying that's a lease. We haven't received those actual contracts from them.
My opinion, personally, I feel like it's irrelevant whether it's a lease or a sale. Now, that might be argued differently, but my opinion, I'm not really taking that into account. It's more the services being offered along with it.
Seems to me that this is another one of those areas that is going to kind of set precedence how we do this going forward. Would it be possible for us to hold this over to the next meeting and give us an opportunity to look at the website, or maybe kind of get us more information on?
I don't think we couldn't look at the website without
That would be no longer anonymous at that point, because that was something that we had talked with the executive, or not the executive director, the assistant commissioner was involved with, talking about whether or not it would make sense to do an informal hearing or bring them in to explain more. Since we have the complaint, when I spoke with our executive director, we felt like this had to go through the complaint process first, be presented anonymously. Either the board has to make a decision on it one way or the other, and then we could bring them in for. But I agree, it would have been much easier if we didn't have the complaint, if they had come forward and said, here's what we're trying to install, let's talk about this. But I don't think we can do that.
Well, to me, at this point, I don't have enough information to say, yes, it is, or no, it isn't. Not sure exactly. Being the newest member on the board, I'm not sure exactly where we proceed from here.
And that's, my issue. I think the lease versus sale argument is, in my opinion, more of a legal issue. I wasn't as concerned with that, but I do think the technology side is something the board should decide. I think this is something that is potentially setting precedent, and I know that the complainant, when I looked at their business as well, because they had said, well, this is almost identical to what we do and we have a license, it is different. It's not a major step in a different direction, but it is different in the way that it's not traditionally recording everything that comes by, or even the other motion detection, that it takes a bigger picture and it's just, we have a motion detection camera and it starts recording or it starts taking pictures of everything that occurs. This specifically is something aimed at cataloging data and then using that data in whatever way the end user sees fit.
I would question some of that description of cataloging data just from the standpoint that a typical NVR these days, that's the way it doesn't just record constantly. It records little snippets, little motion detections all along. So it's not a lot different than a typical NVR. And I would greatly question if they're leasing this equipment and it's in the cloud. They state that after what it stated, it does not do any installation. And somewhere it says Because they don't have access. Once the camera is operating, respondent no longer has access to the camera, its software, or the data collected. If it's on their cloud system, how would they not have access to it?
The way that they described it makes it sound like they create a separate cloud for each end user and that they have sole ownership of that. I'm not sure exactly, if they could, have a backdoor way to get into that, but that was their statement, that it's sole property of the
Their
user.
personnel would have to have a way to get in to work on the system. If something went wrong, they would have to have a way to access that. Even if they have measures in place to secure, limited people, that's part of the purpose of the statute, is that those people that are.
And they would have to be registered. So that's, I think it would be if they had someone who was able to access that, we'd clearly be able to say, no, these people need to be registered.
And Doug, I think what we could probably do at this point is we could ask for more information. We could ask, for staff to go back and try to get more information from them. Otherwise, we have to make a decision. We either dismiss it or we fine or something, but we could ask for more information.
And I think we can, I just got some information from our executive director and our program attorney. Either, we have two other options, I guess, that we could pursue. Either one, we could call them in at the next meeting in front of the whole board. At that point, though, if the board did decide that it was a violation and they wanted to have a hearing, the board obviously would not be able to hear it at that point. It would go to an administrative law judge sitting on behalf of the board without any decision made by the board. Additionally, I guess we could do one board member doing an informal hearing, which then that person would be excluded from a hearing if it went to a hearing.
And it would be more of an informal conference. One of the board members would speak to a representative of the respondent company, and maybe ask whatever questions that you all are having. But when Jesse represents that to the full board, of course, that board member would have to recuse himself or her. Informal option that does give the board the option to, like Jesse said, to defer it until December meeting if you didn't want to make a decision today. Like he said, if the entire board wants to speak with the company, I was suggesting to him that at that point it destroys anonymity and the board would have to allow an ALJ out over that case should it go to a hearing.
My personal feeling is that it is a violation as presented. Discussing, but I'm
At face value, that's my opinion as well. But there could be some slight changes in how this is presented.
I'm going to make a motion that what Scott was saying, that this is a violation at this point. With the information that we were given, it looks like they're acting as an alarm system contractor of CCTV products.
what's our minimum civil penalty? It's $1,000?
$1,000.
I need to include that. All right, I'll eventually get all these rules and orders and stuff down. All right,
I feel you, I understand.
I'll make the motion that, let's see, that they are operating as a licensed contractor with a minimum penalty of $1,000.
Authorizing a formal hearing.
Yes.
Thank you.
In violation of TCA.
Whatever that number is.
I know.
62-32-304.
I second the motion.
Okay, we have a motion by Mr. Fraker and a second by Mr. Cockcroft that based on the information presented today by our staff attorney, this is a violation of Tennessee Code Annotated 62-32-304. Sets a civil penalty of $1,000 and also authorize a formal hearing. All in favor, voice by saying aye.
Aye.
All opposed? Motion carried.
And if this does have an informal hearing, or I don't think we'll have it set for an actual formal hearing by the December date, but I will make sure that that's on the agenda as well if we have the, or whatever we need. And we have number 4, which is 2019-063-731. The complainant works in a local building codes office, or building codes and fire safety office. He made this complaint after respondent he found out that respondent had an active ASC license. The complainant alleged that respondent had contracted with a business owner to install a sprinkler system, fire alarms, and other items to bring the business into compliance with local fire codes. The codes office initially denied plans submitted by respondent as they were not properly reviewed and approved by an architect. Respondent then allegedly resubmitted the plans with an altered architect seal that was used without the architect's permission. Respondent denied inappropriately using the architect's seal and stated that the person hired by the business had reviewed the plans and put the seal on the drawings. Legal counsel for this board made a referral to the state's Architecture and Engineering Board for further investigation, so the recommendation is to close this complaint.
This complaint's against the alarm system contractor, but they're saying they hired someone else that altered the document?
The respondent has an active alarm system contractor license, and it's alleged that he had altered a document by putting a forged architect seal on it to submit to codes, which he has denied doing.
He is saying that a person hired by the business is who reviewed it and put the seal on there. So is that who was referred? Do we know this third party? Did they?
We know who they are, and that third party is the one who had said that they sent it to the architect. I'm not really sure exactly from when we talked to him about I'm not sure exactly how he contracted with this third party to then contract with an architect, but that's kind of how it was laid out.
Do you have any documentation to support that, or do you feel comfortable that it wasn't the alarm system contractor that altered the document?
Well, that's why we made the referral to the state's Architecture and Engineering Board. We felt it was more of a violation there for them to look at as to whether or not there was that forged seal.
Even if it was the alarm system contractor, it would relate more to the Architecture and Engineering Board?
That's correct.
Okay.
On this person that was hired by the business, what type of business is that person involved in?
He's more of a contractor, potentially like a general contractor, not an alarm contractor, because he was kind of going through. Bless you. He was going through the plans as well, but I didn't have his actual credentials.
Now that your recommendation's probably the best, and then if the architectural and engineering delve into something that might come back to us with the understanding they could refer what they found back to us.
And it's typically, when we do find these types of violations on other boards, my understanding is that could affect his licensure, because we do, I believe, when we ask in the application if they've been disciplined by another board. But I think that would be the violation would be, that he was, well, for them, would be that he was acting potentially as an architect without proper licensure. And then we would look at it as, have you been disciplined by another board?
I would think for our board, it would just come into character.
Correct.
Well, I'll make a motion to concur with our recommendations of council to close as it has been referred to the Architecture and Engineering Board.
Second.
Okay,
We have a motion by Mr. Cockcroft and a second by Mr. Harvey to concur with our council's recommendation to refer this to the State Architecture and Engineering Board. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 5, 2019066981. The summary is the complainant alleged that a sales representative with respondent ran a credit check on her without her permission during a door-to-door solicitation. Complainant stated that she called the company after the individual left and stated that the sales representative checked her credit without her consent. Complainant then stated that she wanted to be compensated for her fear that her credit may be in jeopardy. Respondent stated that complainant had authorized a credit check so the respondent could offer her the best possible price for a new security system. Respondent further stated that after complainant called with her concerns, respondent sent letters to TransUnion and Equifax to have the credit inquiries removed from her record. The recommendation of this one is to close.
Motion to concur with council.
Second.
Okay, we have a motion by Mr. Harvey and a second by Mr. Cockcroft to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed?
Thank you. Number 6, 2019068901. The summary is the complainant had a contract with the respondent and the term expired in June 2019. Respondent services then went on a month-to-month billing plan with complainant at that time. With the complainant, and at that time it required complainant to give a 30 days notice to cancel the contract from continuing on the month-to-month basis. Complainant called respondent in July 2019 and requested to cancel the contract. Respondent required the request to be made in writing and then emailed complainant a form to complete it to officially cancel the contract. Complainant later decided to not complete the form and called respondent again in August 2019 to cancel the contract. Respondent again told complainant to complete the required paperwork to cancel the contract. The form was again sent to complainant. Complainant did eventually complete the form and the contract was canceled. Complainant also stated it was billed for services until the contract was officially canceled and the respondent was supposed to refund those funds to complainant in July. Respondent stated that the refund was not able to be processed until complainant completed the required form. Although there was no evidence to show respondent would have been required to make the refund to complainant, and complainant did not timely take the necessary steps under the contract, respondent worked with complainant in good faith. There's no evidence respondent did anything unethical or billed complainant for anything outside of the contract, so the recommendation is to close.
Make a motion to concur with council to close this.
We have a motion by Mr. Fraker and a second by Mr. Richard to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Thank you. Number 7, 2019067471. The summary is the complainant entered into a contract with the respondent in 2010. In exchange for free alarm monitoring equipment, complainant agreed to extend her contract with respondent for another 27 months. Then in May 2019, she agreed to extend her contract for another 36 months in exchange for a lower monthly rate. Complainant was displeased with the respondent's services, and when she discussed canceling her contract, she was going to be charged an early termination fee. Respondent agreed to waive complainant's outstanding fee and to cancel the contract as requested by complainant. The recommendation is to close.
I make a motion to concur with the recommendation of council, as it appears as this has been resolved and it's a civil matter.
Okay, we have a motion by Mr. Cockcroft, a second by Mr. Harvey to concur with council's recommendation to close this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Thank you. Number 8, 2019067651. The summary is the complainant stated that he entered into a contract with respondent for monitoring services and that he no longer wanted respondent services. He stated he felt that respondent had misrepresented itself as another company and that he was charged an early termination fee when he attempted to cancel the services. Complainant further stated that he never intended to enter into a contract with respondent. The respondent provided documentation supporting the contract, Respondent provided a contract signed by complainant that clearly identified respondent's name and the term of the contract. Respondent also gave documentation regarding the installation of alarms at complainant's home. Respondent further provided information from conversations it had with complainant before and after the system was installed. Based on the documentation provided, it does not appear that respondent engaged in any misleading business tactics. Respondent did also agree to waive the early termination fee for complainant as a gesture of good faith. Recommendation close.
What was the further information provided from conversations that, that they represented themselves as a different company?
I'm trying to think.
Or-
Under the second paragraph, the respondent did provide a discussion. It was kind of a typed up summary of a phone conversation they had after that they had talked to the complainant before the alarm was installed, just verifying that they were coming out and sending a representative out to install it, and then a survey, I guess, they did afterwards where they had talked to him. So it was very clear that everything that was provided by them showed their name on it. I'm not really sure why the complainant thought it was a different company, because there was no documentation to ever show the other company.
We just hear more and more of these same complaints. There must be something in the sales process that gives people that impression. Maybe they get beyond that and they're okay with it, but they must feel misled somewhere along the way.
And that's a good question, because I feel like we're not sure what exactly happens in some of those door-to-door solicitations since they're not recorded. A lot of that is more of a he said, she said at that point. It is odd that we get these complaints where they say we thought it was company A, but now we're getting the bills from company B. We figure those ones out when we see, okay, well, company B has bought company A, or there's some document in between. This one, there was no documentation provided that showed anything, I guess, other than the respondent's name on it. I mean, the contract clearly had complainant sign it. I mean, it wasn't even electronic signed. He had actually signed it, and their name was clearly on the top of it.
I'd make a motion to concur with the recommendation of council to close, as it does appear that it's resolved. That it appears as though they paperwork or anything is a different company, or they did demonstrate they were a different company.
We have a motion by Mr. Cockcroft, a second by Mr. Richard, to concur with our council's recommendation to close. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Thank you. Number 9, 2019-069731. The summary is the complainant entered into a contract with the respondent on January 27, 2018, to have alarm monitoring services in her home for a 5-year term. On February 25th, 2018, the alarm went off and respondent called the complainant. Complainant told respondent that the system was malfunctioning, and respondent stated that they would contact the technical support office about setting up an appointment for maintenance of the system. Complainant stated that the alarm went off every time that the door was opened, and that her passcode had stopped working 2 days prior, so she relied on the fob to stop the alarm. She then stated that the fob stopped working on the 25th, which would be the 25th of February. Complainant did not make the respondent aware of this issue with the passcode and the fob until the 25th. Respondent's technical support attempted to schedule an inspection of the system on February 26th. However, complainant stated that she wanted to cancel the service, as at that point she was worried about her system not being actively monitored, and that it was not monitored between the 25th and 26th. Respondent claimed that the system was being monitored during this entire incident, and that when they tried to set up the service appointment, complainant stated that she only wanted to cancel the contract and services, and did not want to have the system serviced. Complainant made this complaint over a year after she and respondent were unable to settle their disputed owed balances, and respondent sent this matter to collections. By looking at a copy of the contract, it does not appear that respondent charged complainant for anything outside the scope of the agreement that could constitute misconduct. Respondent appears to have made a good faith effort to have the system inspected and repaired. However, complainant did not want to have these services done, so the parties came to an impasse. The recommendation is to close.
Make a motion to concur with council and also notify the complainant that is more of a civil matter than a board matter.
Second.
Okay, we have a motion by Mr. Harvey, a second by Mr. Cockcroft to concur with council's recommendation with a letter sent to the complainant of this being more of a civil matter than a board matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Thank you. And this should be the last one then, number 10, 2018 070561. This is a represented case, so under the initial summary, the complainant alleged that respondent was not licensed and advertised to its clients in Tennessee, or advertised that has clients in Tennessee. Respondent states that they have no person selling, servicing, or installing alarm systems in Tennessee and are not engaging in alarm system contracting. Respondent does not employ anyone or have offices in Tennessee. Respondent states that they are an alarm servicing network and provides local contractors to a customer retailer, and if the retailer chooses the contractor, they then receive an invoice directly from that contractor. Research shows that respondent is a manufacturer of security products and provides these products to several retailers for loss prevention purposes. After an investigation, it was determined that respondent had provided burglar and some of the fire and alarm monitoring for retail stores in locations nationwide. This information was confirmed by the Director of Loss Prevention for respondent. Further, respondent has been provided monitoring services for certain retail stores for 7 years. So the initial recommendation was for a $5,000 civil penalty. Under the new information on this case, we received a subsequent complaint, number 2019-043561, and that was earlier this year. And after a more thorough investigation was completed into the actual services performed by respondent, respondent is predominantly an alarm systems network provider and does not provide any actual alarm monitoring or installation in Tennessee. Respondent provided information as to the licensed individuals who perform monitoring and installations for respondent. The investigation in this complaint at hand was mostly focused on collecting information from respondent's customers. Based on these documents, or based on their documents, advertisements, and their website, there are concerns that respondent was holding itself out as a licensed alarm systems contractor and potentially advising customers as to the systems. However, there was no evidence that respondent was actually performing any unlicensed installations or monitoring. Legal counsel for the board has had lengthy discussions with respondent's counsel about what would need to be done to bring respondent into compliance with the board. Respondent has agreed to become a licensed ASC within the next 6 months and requested the $5,000 civil penalty to be lowered to $1,000, as was decided by the board in the more recent complaint. So the new recommendation for this one was to authorize a formal hearing and a civil penalty for $5,000 to be reduced to $1,000 if they agree to become licensed within 6 months of signing the consent order.
So the original finding was for a $5,000 civil penalty, and then there was another complaint?
There was. The second complaint that came in was presented to the board, and we did a very thorough investigation to figure out exactly what was done. Under the first one that we had, which is this case we presented, most of the investigation was looking at a few of these stores. We found the stickers on the boxes, and it seemed like the investigation had stopped at that point. Under this one, we got more details about who was actually providing the monitoring, who was providing the installation, and what stores specifically, or what's being provided to each stores. This was also one, well, under the new complaint, we had found that they had been sending from their out-of-state office blueprints to the customers here, and that's where we had said that they were advising and selling the systems. So I do think, from my discussion with their counsel, their intention is that they want to be more of an alarm systems or a network systems provider. They don't really want to get in the business of monitoring. They don't want to be in the business of doing the installations, but because they are, one, holding themselves out as a systems contractor, and two, because they are technically advising as to the systems based on these blueprints, that they do need a license or they need to stop doing that practice. So they had just requested that we drop the penalty at that point down to.
What do they do if they don't provide monitoring and they don't provide installation?
So what they actually do, and this was discussed, I guess, in the more recent complaint, they contact from their contacts with these nationwide chains. They get a blueprint from them of the store. They go through, mark it up, and say, here's where we think that you should put the alarms. They send it back to them, say how much it'll cost. Once they agree to that, they find someone in the state who will go and install those systems, and that person's a licensed contractor.
They're not selling it, how would they know what it costs? But they also admit then to designing the system, and that in of itself
And that's where the violation
is a violation.
So that was the discussion with them of they would either need to no longer do that and just have some other contractor go out and say, here's where, advise them as to where the system needs to be provided, install it, sell it, and then they would just hold those documents then and just do all the billing because they could do it that way, or that they would need to get the licensed. And
Are they presenting it as though they're not subcontracting the monitoring, that they don't even do the monitoring? They don't subcontract it, they don't do it, this other monitoring company bills them directly?
so I think that's where there was an issue with what we had discussed with them as well. Under the first complaint, this one that's being represented, we were under the impression that they were doing the monitoring. And then when we went under this second investigation, started figuring out what was actually going on, it was determined that there's a licensed person in each state who does that monitoring.
But even if there's a licensed provider and they're just subcontracting with them, they're still considered the primary contractor. The respondent would be in violation if they're subcontracting it to licensed contractors. Technically, the licensed contractors would also be in violation for, working in conjunction to circumvent the law with an unlicensed contractor.
I think with the licensed monitoring company, I think the only thing that would, I guess, keep them from having the violation is the provision says that a licensed contractor can't subcontract. So I don't know if the monitoring company would be considered subcontracting that portion to the other company, or entering into a joint venture with them. That would be an issue if they were doing that. I think, though, if they're being billed by if they're being billed by respondent for those services, and it clearly says your monitoring is provided by this company, I think at that point it may be okay at that point. But I agree, if they were holding themselves out and saying, we're providing that, and the customer believes, well, respondent's the one who's providing the monitoring services, even though when we call, if there's a problem, it goes somewhere else. I think that would have to be the distinction.
I just feel like the response is trying to dance around the issue and not, I honestly just don't feel like it's an honest response, because why would a national company, why would they just help out these nice people for no monetary involvement to find them somebody to monitor the system for free, find them somebody to install the system for free, I assume design it for free, which the design in of itself is a violation. I don't buy the response.
I think they are designing it, and I think that's where we found that was that violation, was because we know.
Do they charge for that? What are they getting? What are they making out of it?
That's what they're getting paid for. And then
Just
I think
the system design.
And then I think they probably also are getting money on the top of that monitoring fee.
And if their stickers are on the job, that would suggest to me that it's more than they just found someone to install it. If someone from out of state called my company and said, "Oh, I've got a customer for you that would like an alarm installed," I'm not putting their stickers up. I mean, that seems very strange to me.
And I think that's an interesting issue in and of itself, because we've gotten that response from respondents before, that they are finding licensed individuals to do the installation for them. I do know from going through another complaint, going through some of the documentation we got, there are these websites right now that are finding individuals who are licensed to go do different installation jobs, and it's everything from I saw that they were talking about installing cable, which I'm not sure why a cable company would subcontract that, but they talk about finding different people. And the individuals' names that they did provide, we did verify that they do have licenses. So I think they're smaller companies, certainly.
And I don't doubt that the monitoring company's licensed, that the installing company's licensed. I don't really find them at fault. They probably shouldn't be involved with someone out of state that isn't licensed, but I just think that the company that's the respondent in this, I don't think they're being entirely truthful with this response.
So what I know about the subcontracting of local companies is big business. you've got ABC Company, and they sign a contract with Ma and Paul's clothing store that's opening up across the country. Well, ABC Contractor or Alarm Company doesn't have people in 50 states, so they go local. Yeah, there is Facebook groups. I see those all the day long. They're looking for licensed subcontractors. My company has done it in the past. That's how we started our business. We were subcontracting for these national companies. Of course, we've cut that way back to nearly nothing now, but
I've done it too. I've subcontracted for national companies, but not if they're not licensed.
But not if they're not licensed, right. And then
Usually I don't get any callbacks after I ask for a copy of their license. It's like,
Right, yeah.
oh, never mind, I didn't need anything.
I didn't need you, right, and I agree.
How long has this business been doing that in Tennessee?
In Tennessee? I think when we looked under the initial one, well, it would probably add a year. So I think we're thinking potentially 8 years now.
Okay, let me ask, are we having this discussion because they want to get licensed? They're saying, we're going to get licensed. I think what we're discussing here, or need to be looking at, is the penalty.
Right,
reducing the
you're right.
penalty.
And we do want to see them brought into compliance. I guess the fact that they want to reduce, we got, not only, they didn't pay the first civil penalty, they got another complaint, and so now because they got a second complaint, they want us to lower it, when in reality, we ought to make another civil penalty. I'll make a motion to I don't know how to word this, but I would not make any changes. I would stay with the $5,000 civil penalty. We want them to come into compliance, and we would welcome that, but I don't see any need to reduce the.
I'm going to make a motion a second, I mean. Yeah, he already made the motion.
I was waiting to see what your motion was going
I
to be.
just want to second it.
We have a motion by Mr. Cockcroft and a second by Mr. Fraker to stick with our original civil penalty of $5,000 in violation of Tennessee Code 6232-304 and to continue to authorize the formal hearing and encourage this company to become licensed. All in favor, voice by saying aye.
Aye.
All opposed?
All right, thank you. And that concludes the legal report.
Okay, next, are you ready for the appearances?
Well, did you mind, Madam Chair, if we took like a 10-minute break before
No.
we go into the appearance? The gentleman is here, but I'd like to have a break first.
Okay.
Thank you.
Okay, we can call the meeting for the Alarm Systems Contractor Board, October 17th. We're back in order.
Yes, I think what we had was our appearance. If you look, the gentleman is with us. I believe, Mr. Lawrence, have you signed in?
Yes, ma'am.
All right. Come on up here to the podium if you'd like. Just, when you talk, please do make sure that the red light's on, but just give them just a moment to look over what you had sent. Talk to us about the Memphis ordinance, if I'm not mistaken. A question about education. People had already seen this and had asked us to write a letter, which our attorney did. And we did get a response from Memphis. She wrote the letter on April the 16th, and we got a response in May. That wasn't this month? Okay.
It was disappointing that we were taking a long time to draft the letter. We didn't even get, when I asked about it, we hadn't even sent the letter. Basically, I guess we just took their response that we're not responding to it or taking.
No.
We have not sent a response to that. In my research, honestly, and I'm not sure, Mr. Lyons, what your question or comment is in regards to. Looking at the Memphis ordinances, they have specifically defined what a false alarm is versus what the other things that they are citing citizens of Memphis for, and those things are not covered in our statute or what the board regulates. I'll defer to Mr. Lyons. I'm not really sure what his question is.
Okay, please introduce yourself and your affiliation and so forth.
Yes, ma'am. My name is L.J. Lyons. I'm a representative of the Tennessee Electronic Security Association, but I'm also here as just a concerned individual for the security, fire, and life safety industry, in the state of Tennessee. I appreciate you, ladies and gentlemen, giving me a few minutes to speak today. I won't make this too long, but as y'all know, Memphis passed an ordinance last year that our association, the Tennessee State Association, felt it harmed its members and harmed security dealers. And we followed all the proper channels. I met with them individually first, and that didn't work. We hired attorneys, and we met with them with attorneys, and we ended up having to fight it out on the Hill over here. And ultimately, the fight on the Hill, we were able to win that particular battle. But at the same time, a lot of stuff come up. I'm not trying to add to this board's.
You said the ordinance they passed harmed or punished a lot of people. Explain to us what the original ordinance was.
Yes, ma'am. The original ordinance that they had passed said that they were going to make the businesses, the alarm businesses, responsible for third-party permit fees and jointly responsible for the false alarm fees for its customers. And we felt that harmed our businesses. We hired attorneys. The attorneys looked at it and said, this is not right. They can't make you pay third-party fees. Again, we had this battle on the Hill. And what I say, not to add to this board's dilemma, but the senators and the representatives on the Hill, I met with every single senator, and I met with more than half the representatives. And this board was brought up several times in that conversation. Where's this particular board are the ones that's supposed to be protecting the alarm business on the alarm law, and what was their stance on that? And we told them, look, we filed a letter. Some of the senators and representatives are actually attorneys or have a legal staff, and they'd actually looked at the ordinance and said, what they're doing is illegal. They felt it was illegal. So ultimately, we did win at the state level, but some other questions had come up about, okay, who's doing what here, and why is Memphis allowed to do that? Now, I did read the letter, in response to that, and I also believe that everybody in this room, including the AV gentleman in the far back, knows the intent of the law. The $50 penalty was that the total penalties were not to be over $50. So I understand what Memphis's response was, that they feel it's remedial, not punitive, and that it's not a fee. I did read their letter in depth. I'm very familiar with 6232. I've been in the security business a long time at the state and the national level. We can argue the semantics with them all day long, and whether this board decides to just accept their letter or whatever is fine. But we did expect a response from this board, and the fact that what was legal counsel's opinion is that the vote, or do you need to take a vote? Do you want to do? We wanted a response from the board because we still got a lot of members that are talking that they want to go to the Attorney General. We've got representatives on the Hill that have said they might want to take a letter to the Attorney General to get him to decide whether that's a violation of the law. The spirit of the law, the penalty is not exceeding $50. And again, that part of it, to me, is whatever the law decides. It's whatever this board decides, whatever they decide, and we'll follow along with that. Our main thing about the ordinance is that we felt it was damaging the companies and illegal. We hired 3 attorneys, and they all said they can't do what they were wanting to do. And so we put that in there.
So
Again,
did that get changed where the companies, or is that still pending?
No, ma'am. After we passed the state law last August, Memphis changed the ordinance to the original recommendations that we had made to them when this started. Another big issue that had come up is the notifications that they put out to the public didn't match the ordinance that they had passed. And so that was another issue that we thought that we had to get the attorneys involved with, but ultimately they did change it. It is changed right now on the who's responsible for the fees. All that part changed. However, their recovery fee, as they're calling it, is still in there. And again, if the board decides to just accept their letter at face value, that's fine. That's this board's decision. But there will probably be more said about that, even after leaving here. I mainly wanted to come and ask you if this board had any questions about why we passed the law and the extent of that battle, because they did fight it to the end, even having somebody say something on the floor when it was up for vote after it passed the Senate. But again, ultimately, we were victorious in the votes for that to get the law changed the way we felt that it should be after attorneys and lawyers and everybody got involved with that. And I'm not expecting the board to make a decision today by any means. I would just say that we would definitely like some type of either legal counsel's recommendation or the board's reaction to their letter. And then I can either wait or go on to the next topic if you'd like.
Is it 25 or 50 as they say after?
It's $50. Just a couple of things. What Mr. Lyons is referring to is Public Chapter 315 that did, in fact, pass. That was signed into effect April of this year, April 23rd to be exact. That is correct that the alarm contractors are no longer responsible for that. That did not speak to the letter that I sent to the city of Memphis. The letter that I sent to the city of Memphis was in relation to an email that Cody had received in relation to the individuals being charged exorbitant fees, or what they felt were exorbitant fees, and that's what my letter spoke to. I was unaware that there was question regarding how the board relates to those particular contractors, because as you know, the board is charged with regulating the industry in an effort to protect the citizens of Tennessee, not so much protecting the companies, but regulating the companies to protect the public. And so I think Mr. Lyons, of course, can expound on what he and his colleagues are seeking from the board as far as guidance or response. But I did just want to make clear for the record that our letter was regarding a certain email we received that included news articles. So that's what the letter was referring to.
I do think that one, your letter was for the benefit of the consumer as well, because, that's who's getting the fine. The alarm company wasn't getting the fine. There was the possibility that they might direct that at the alarm company. The other issue that the industry took, that LJ's talking about, was where they were trying to hold the alarm company responsible for the permit ongoing. I don't think there's any other industry that I'm aware of that, like if you buy a car, yes, the dealer gets the registration to begin with, but he doesn't have to pay for your tags every year. He doesn't have to, and I don't, if you get a pool or something, a pool permit, I don't know that there's any other industry where a municipality is requiring the contractor that installed it, because it could even be an alarm company installed an alarm system and then they're not even the customer anymore. They may be, they weren't saying they were holding the alarm company accountable for that, but that's not what the ordinance said they could. The ordinance said that they could hold the alarm company accountable, or that they had to pay that permit fee every year, even if that customer canceled or never did anything.
So what's the permit fee?
In the ordinance, or the state law allows for a local municipality to have a permit for the alarm, just to have the alarm. You charge a permit fee to register it, and they can,
And then this Memphis had one where it was, you had to renew it annually, correct?
right, and they've had
But
that for a
then that's
long
where they were
time.
dragging the alarm contractors in, that they were responsible for collecting these permit fees,
Right.
correct?
And for a number of years, the alarm contractor was responsible for getting it initially, and I don't think most contractors had an issue with that. The issue was that they passed an ordinance saying that they had to get it every year, that they had to pay it and then get it from the customer, as well as there was the potential wording in there that even the false alarm fines would be directed at the alarm company. But the permit issue was solved. There was no real change or anything to our statute has a $50 maximum penalty or fine. Memphis is charging a $50 penalty, and then they're charging a cost of service fee or something, or
They're calling it a recovery fee.
but I don't believe that they charge that for any other police response, do they?
They do not. It's only if you have a dispatch, a false dispatch.
I mean, as far as any other type of police response, if you
No, sir.
call because you heard somebody outside, they're not charging you a cost of service. If there's somebody that has a domestic dispute, granted, they need to be there, but they're not charged for a response. An auto accident, I don't think they're charged for a response. So it's clearly meant to be a punishment or a penalty, and they're trying to circumvent the statute that we are over. I just don't know that we have that much to do about it. We're really regulating the alarm companies. The law is there. I would think that someone could challenge the city on that law, but I don't know what we as a board can do. I mean, we tried to tell them that they were in violation, and they just responded saying they weren't.
I would like to clarify, the reason we didn't bring the permit issue to this board is we thought that it was directed at the business and out of the scope of the law, because it didn't, in their attorney's opinion, it didn't harm the public, it were just harming the business. And they kind of thought that was okay. Well, the businesses didn't think so. So again, because the $50 cap was in the state law to protect the consumer and the public, that's where we felt the recovery fee fell over that. And I did look, and the other topic I had partially was about updating the alarm law. I know from hearing the past minutes and what everybody said that there's a lot of things that they also fall into a gray area now because we don't have the definition for them. I know Webster's dictionary for penalty, for fee, they're all synonyms, they all fall together. But Memphis is saying legally, well, you don't define a penalty. And we've had a lot of conversations about some of this, but we weren't going to, as a business, we weren't going to try to sue the city because they're fining the customer. We feel it harms the public, yes, but that would be for the public, as Mr. Scott said, to take that up, which there was talk about a class action suit, and a bunch of people wanting to sign up for that. And we as an association wouldn't support that. We said, well, that you're going to have to give that to the state law. If you think that it's in violation of the state law, that would have to go to the state law, and unfortunately, it falls under this board. Again, whether you can do anything about it or not, because it's not defined in your ordinance, or defined in the law, excuse me.
From reading this letter, they have a $50 false alarm penalty, and after the second verified false alarm, I mean, is that within a certain period of time that?
Yes, ma'am, it's within a year. They start finding people on the second one.
So within a year, you can have one false alarm, but the second one triggers a $50 penalty plus a $50 recovery fee?
It's a $90 recovery fee. They charge the end user $140 for intrusion. For fire, I believe it's over $200. I think it's $190 or something like that. So on your second $250. So on your second alarm for fire, you're going to get the $50 plus the recovery fee. You're going to get hit with almost a $300 bill.
Ordinance the city ordinance was not even about fire, but they're charging fire.
That's right.
Fees.
And again, we legally looked at that, and we could take that up, but we had such a time. It took us 6 months on the Hill to get that law changed about the ordinance. And so again, we felt that was out of the scope. We did make a recommendation to the fire commissioner and the police commissioner in the city of Memphis that they separate that because of licensing, not just because of the Tennessee licensing, but because of the insurance and NFPA and codes and standards. And they told us, well, you can just cut them off. Well, I can't cut a fire account off. I can't just cut somebody off because they didn't pay the city their bill. And, that we can't do that. We can't be responsible for that. So
I have a commercial fire alarm in the city of Memphis. You have to pay code enforcement a permit fee. You have to pay the fire department a fee, and you have to pay Metro Alarm a fee. What other fees are there? Is there, you've got to have, Metro Alarm is Memphis, is alarm department.
it's actually just the alarm office now because they divorced from the county. So now it's just the city. When they passed the ordinance, the county never passed the ordinance with the city. They wouldn't pass it. So partially because of that, recently when they did a rewrite, they cut the county out as well. So it's now just the city. It's not city and county anymore. So it's no longer the Metro Alarm Office.
Other thing, you also have to have UL or FM certified, so there's a cost for that certificate or fee. So there's the
And I'm not here to argue about all of that. I just mainly was pointing out the issue with the fact that many of our customers and the public felt that they were violating the $50 statement in the law. And
If I can ask the board, and I'm not sure how much knowledge you all have in regards to this, but I'll defer to you as the subject matter experts. As you know, you do have the authority to promulgate rules. Do you find that this is a problem prominent enough to warrant discussing maybe drafting rules to define false alarm or define some of these terms? Or is this a Memphis-specific problem or Shelby County-specific problem that may need to explore other options of addressing?
I think the concern is that if it's left undealt with in Memphis, that it could spread to other, municipalities. If that's the intention, is if the legislature feels like that's okay, I think they should change the law to change the $50 max. But I feel
the way I will say, the way that I read the City of Memphis ordinance, it's not necessarily the false alarm fee that's $50. The $90 is the false dispatch for police or false dispatch of fire that would result in a $250 fine. That's the way I read the language of it. I'm not sure exactly how they are applying it because I do live here in Nashville. But looking at the ordinance and what I read seems to indicate that the actual language says commiserate to the cost of officers answering false alarms, and that's $90. So the false alarm going off may trigger the $50 fee that's allowed in state statute, but then if the police go and it's a false dispatch, that may result in that consumer or that citizen being charged an additional $90 for that. Again, like I said, I'm not sure how that's applied in Memphis, but that's the way I read the language of the ordinance.
they were definitely very crafty, and it just seems like that it's a false alarm fine. I guess that's something for the courts to decide somehow, but it doesn't. If we don't, I mean, I guess you're saying we could make a rule and define a false alarm fine?
If the board finds that it's prominent enough that they need to step in, that there's a danger or harm to the public in some way because of the way that this is being applied, I think that's where your authority is, if you feel like you need to define those terms. Short of that, I'm not real sure how the board wants to address that.
Ashley, when, say, a person amasses a $500 recovery penalty, all this, what happens if they just don't pay it?
They can go to non-response, right?
Yes, sir.
A fire alarm they can go to?
The way that it's set up, they can just cut them off and stop responding altogether, or they can just keep doubling and tripling the fee and then send them to civil court. The one other thing that I thought was very crafty about the law, and our attorneys pointed this out, for you to fight the $140 or the $250 fine on your second offense, so you have a faulty piece of equipment, whatever it is, you actually have to go to civil court. to rebut that, and those fees are more than that. So it's just cheaper to pay it and then go on, unless you start amassing some pretty decent calls, and it comes up there. Ms. Vivian, would you mind if I address something Ms. Ashley said?
Oh, no, go ahead.
One of the reasons we fought so hard against the ordinance in Memphis is because we had already been told by many people, if Memphis was allowed to do this ordinance, that not only was it going to hit all the major cities in Tennessee, but then they were going to start doing it in Arkansas. And so we understood that we wanted to stop it as much as we could there. And the same thing with this. I've already heard other people say, well, if we can call it whatever we want, then we don't have to care about the $50 anymore. So that's why we wanted to take such a stance on Memphis in the ordinance, and why we put up the fight here at this Capitol.
What I find real interesting is they're going to call it a $50 fine and then the recovery fee. So how would I ever get just the $50 fine? Because you're always going to get the recovery fee. Because
Like I said,
a dispatch is, I've called the police and they're going to respond. So when would you ever get just a fine? You're not.
Having come from law enforcement, I can be honest with y'all, there used to be alarm systems that were inherent problems for us. Sure. They went off on a repeat basis over and over, and of course we were mandated to respond, okay? So we did tie up a lot of manpower for ridiculous, because there's no way to get the company, the owner, the business owner, to get the alarm fixed. Okay, we have, I think Chattanooga did eventually start with a false alarm fee. However, to me, maybe there needs to be more alarm, or more faults before you start activating all of these fees. It could be something with the battery goes out, because that was one of the biggest things we had, was like the battery backup system on the alarm system would go out, and it would trigger something. And I know the technology's changed, but safe alarms, for example, in department stores used to have a battery backup, and when it reached a certain level, it signaled trouble, and then it called the police, and we responded. We didn't find anybody. To me, there needs to be, and I don't know that we have any jurisdiction into what Memphis does as far as their, quote, recovery fees, because it does cost a lot of money every time you roll a fire truck out of the hall to go respond to a false alarm. I don't know that this board has am I right or wrong?
I don't think that
These
the fire
recovery
alarm,
fees.
I don't think the fire alarm issue is much of an issue. They were already charging at times, weren't they, for fire response?
I don't think the fire alarm is the main issue. And one other thing is, you said, ma'am, about the technology. So I'm going to show my age here just a little bit, but in the early 90s, almost every alarm customer was good for 4 false dispatches a year, and it was just a rampant problem. And today, that number's down to 0.23. 77% of the time, we're not even responding. We're cutting that off and not sending a dispatch. So now for every 4 monitored people, we've got less than 1. And so the false alarm, as much as we would like no false alarms, because we do not want to eat up the resources of police and fire, those numbers have gotten much better with verification methods and all that. And now I will say this also, another reason we didn't push as hard as we would for the $50 issue is they are, on the record anyway, giving that money to police and fire. And that had come up on the Hill when we were fighting them, that we were against police and fire, and I really took offense to some of the stuff that was said on the Senate floor, and that's why I rebutted that, is because I've been in the emergency responder myself. I've been a fireman EMT for over 20 years, and to say that I would be against police and fire is just inaccurate. So again, I'm not expecting necessarily a decision from this board because it's not defined in the definitions. But it does fall under 6232. And so we were, it might be something that you have to give the legal counsel what, but I know a response, we need something to tell the public as far as businesses about, hey, what are they doing? Or when I get asked from another senator or representative if we've even discussed this with this board.
One of the frustrating things about Memphis is that there was already an ordinance in place that addressed false alarms and had fines in it, and had classes and different things that also, they could go to non-response, but they weren't enforcing it. They went from zero enforcement to passing a totally new ordinance with all of these new cost of recovery stuff. If they'd enforced the old ordinance, they would have had a better outcome. They could have reduced false alarms, but they've gone to just collecting money.
We've offered to help them as a state association. We've offered to help them. I mean, I met with them many times. I even met with the mayor's people. I met with the people that drafted the ordinance. I met with a lot of people, and their answer to that was they officially have written us off of that board. We're no even longer part of the review board because of our actions here at the state level.
There's supposed to be a member from the industry on the board, right? Then,
Again, they've taken that out. The mayor, we don't get to appoint or choose a person anymore. That's all going to be done by the administration.
they didn't come to the industry at all before the ordinance was passed.
And I do have some other quick things, but whatever you want to go over this.
On the fire, I was just thinking about I think fires, to me, the costs there seem more fair because they charge a cost if an ambulance goes out or other things. So it's not like someone with an alarm system was singled out, whereas the burglar alarm side of it, or hold up, that's where they're charging their cost of recovery that they're not charging on other type calls to a. If someone thought they had been broken in, they heard something outside and called the police, it's a wasted call for them too. That's also time they had to go out there, but they're not charging them for that. But if you pushed your panic button to do that, they'd charge you a false alarm.
I think it gets subjective when you say, I can have a prowler at my house, and if it takes the police 7 minutes to get there, that doesn't mean the prowler wasn't there because the prowler. So, I can't really go along with that analogy. Go ahead.
7 minutes, you must live in Chattanooga. The reason I'm joking about that is the police response time in some cities in the state of Tennessee is 45 minutes to an hour. So.
But my point is, you can have a prowler when you call, but that doesn't mean that prowler is going to be hanging around when the police get there, that I should be fined because I had a prowler, but because your response, I don't go for this fees for service stuff because police are there to serve, not to get charged people like that. So,
well, I'll let y'all chew on the $50 thing as long as you like. So, the other thing I wanted to mention to you is that some of y'all might know that the National Association, the state of Tennessee, the TANISA, the Tennessee Electronic Security Association, was part of the National ESA Association, and we had been for many, over 20 years. We partnered with them with the training because it was nationally certified. We've done a lot of things. They decided themselves to cancel the agreement with all chapters, including Tennessee. And so now we're faced with options as a state. And so what we have decided to do, because we're in a position that we can do this in Tennessee, is we're not going to join another national group and all that. We're going to try to be on our own for a little while, and which includes the training. And so when we talked about stuff that needed to be updated in the education and in the law part and all that, we put in the minimum training level would be the national level 1, and that would be the minimum. And in looking at the list, and I mentioned, I come and spoke to this board about it when it happened years ago, but there was a 2-day, 16-hour course with a non-proctored exam that got approved as a training equivalent. And the minimum should have been 3 days with a proctored exam. And I remember me and Mr. Ken Roberts had a lengthy discussion here. I was sitting there and he was sitting there back and forth over that. And so it is what it is, but we're going to be developing our own training program. And we're in the process of it right now. We'll be getting it approved, and we were going to fill out all the paperwork as soon as I get the lesson plans completed. and try to get approval before the end of the year. But if you're not going to have a December meeting, I might need to know when, and I need to put it in paperwork. But, you know, we can't leave the people in Tennessee just left out as far as the companies, the employees. We have a requirement here in Tennessee. And because National decided to change their stance on partnering with the states, we have to do something different in Tennessee to help that. Now, the level one, obviously, you'll still work. You get all the people that are still taking level one, and we assume there will be national companies and people that use the level one still in all the other states as well. But instead of allowing the Tennessee State Association to be mandated by another group, we're going to try to go at it on our own. We've been fortunate enough to have our own executive director. We have our own lobbyist. We've been able to, we have a decent board. I know this is being recorded. I got to be careful. We have a decent board, and we're able to do some things that other states and chapters can't. There's a lot of states with smaller chapters that are already given up. They're going to just fold up their tents and disband. We're not going to do that in Tennessee. We've always felt that the regulation, including 6232 and the training, was wholly in part to protect the public. We believe in the background checks, and we believe in the training. To the fact that myself and many others put tons and time and money and experience and all that into making that good for the people in Tennessee. And so I want to make sure this board knows not only are we going to go at it on our own, we're going to be developing a Tennessee training program, and we're actually going to add Tennessee state law to it. If it's going to be a Tennessee program, then we want it to be unique to Tennessee. So I want to put sections of the law in there so that people know. Many states do that now. And I wanted to know from this particular board if there was any recommendations or anything that you felt pertinent in the state law or the rules or regulations that you wanted in there besides what we chose as an entity that's used to doing this for states. I'll be glad if there's anything particular you wanted to add to it, I'd be glad to put that in there, but that course is in development as we speak.
Probably one of the most important things that we see so much of is where employees aren't registered and the requirements for registration and that.
It's already in the outline.
Who needs to be registered?
Yes, sir.
The fact that they need to notify if there's, if they're.
Self-policing? Yes, sir. That was the other complaint that our members have been telling us as a board is that it's almost the Wild West in Tennessee now. At one time, with our association and everything, we were one of the most looked at chapters in the industry. And we've kind of lost that over the years. I'm not saying it's this board's fault by any means, because there's different things we could have done. We could have toughened the licensing laws up. I met with the fire commissioner years ago about putting some sort of requirements for fire, and the members just didn't want to do that. So we're still getting a ton of complaints, and I don't know whether it just is updating in the law that would help for the DIY and the exemptions for telecom and electricians and a bunch of this stuff that keeps coming up. But again, I've been looking through the minutes of the board. Y'all are fighting the same thing. You're hearing it all the time. Well, we don't fall into that category or things like that. So I don't know if updating the law is going to fix that, but the technology has changed so much, a lot of people can say, well, I don't fall under the electrical code anymore. I don't need to know anything about that. I'm all wireless and this and that and the other. That's not the intent of the law. The intent of level one is not to teach you how to put a system in. The intent of level one is about job safety. The intent of the law is about having a background check before you go out to the public. I mean, I'm preaching to the choir, I know, but some of that stuff we really need to update and fix. As a state association, we'd be glad to help you, but we definitely think we need to lean toward that area of cleaning some of that up.
Oh, okay, let me speak for just a moment. I don't believe it's your position as the board to help this association write a test that they're going to administer or change. Yes, we would love to have any input about some changes to be made to the statute or to the rule. Actually, to the rules. We may be coming up later on next year at a rulemaking hearing, and that would be the time to do that. So, yes, that's when we're going to ask for the public comments for you to tell us what the association like to have. But I wanted to ask, what was the benefit for the National Association to do this?
There's a lot of different opinions on that. There was a couple chapters that was leaving them anyway, and there were some things that happened over the last 2 to 3 years that they wanted to reduce the board. They felt that for them to grow, they didn't want a rep from every state, and that failed because the states didn't want to vote themselves off of a board.
The board for the National Association had a representative from every state. So can you imagine that dealing with that board, just dealing with this one?
That one time, they were at 38, I think, and they had meetings, it was quite costly and large, and but the reason they didn't want to do that, the National Association was made up of chapters, and that was always, in my opinion, one of their strongest suits, is they had all these chapters that helped fund that helped create the material, that helped get their stuff nationally recognized, and now that they've separated from those, a lot of states are going their own way. And instead of putting Tennessee in a bad position with another national group, we're just going to try to manage it ourselves going forward. Now, I understand about the comment too, but obviously it's not this board's place to give us content. We're going to take care of that, but if there was something particular that you wanted, we could definitely make that part of the course, because several states do that. They put their licensing law in the state course.
I don't think that was necessarily inappropriate to ask that question, because we'll be reviewing what he turns in as a class.
Turns in, yes.
If he turns in something with everything about how to put in a swimming pool, we're going to say, this isn't a very good course.
It's all wireless, don't worry.
Okay.
What I would like to ask, though, if the association as a whole, or your board members or whatever, have any suggestions for any law change or any, if you would put it all together and give it to me, I would really appreciate that, and I'll sit down and take a look at that, because we are looking constantly at the laws and the rules, and it's another source for me to be able to go to.
Yes, ma'am. Madam Chairman, that's all I had. I want to make sure you didn't have any questions for me.
So you were just, was there anything about the training, or you just telling us about that, or?
I want to make sure y'all know, well, I am under the impression that the way the law reads, and our intent of the law for that, was that the level 1 was the minimum 3 days proctored exam. How a 2-day course without a proctored exam got approved, I don't know, but we are of the opinion that we're still going to keep it 3 days with a proctored exam. And so, if that's not the intent of this board,
Saying the board voted for a 3-day course?
Where is that? That says level 1 is 3 days.
where it says level 1.
I thought it
Where does
had
it
to
say
be a
in our
level
statute
one.
by level, then we don't even address level 1.
It does address in there that one of the minimum requirements would be that class.
That class
Is that-
of level 1, but it doesn't define what level 1 it constant.
Well, but level 1 does have a definition of what it is. I mean, it's always been a 3-day class with a proctored exam. If you hold that out as a minimum standard,
Who set that? Did the board do that, or is that what?
I believe that's statute.
Yes, sir, in the employee, where it's the original employee training, at the top of it, it says has to meet the MTS level 1 or equivalent, and the board gets to decide what's equivalent.
Right. And I guess Cody and I, what our question is, was there ever a point where the board decided that what that equivalent or level 1 was 3 days in a proctored exam?
I think something that happened before I was here. I don't know. I mean, and I don't know that it was ever defined as it was 3 days in a proctored exam.
And I just wanted to be clear for the record, because Mr. Lyons, part of your comment made it sound like that was what the board decided level 1 was defined as. I just wanted to be clear on that.
I mean, whenever we did that, we put that in the law, we turned in the lesson plans and all that for a 3-day outline, that it would be for that standard. That's why it was worded that way. And our lobbyist helped put that into the law. And so, again, this board gets to decide what's equivalent, but I want to make sure that when we're designing something for Tennessee, we're not just underdoing it. We want to do what's best for the public, so.
Somebody could present a class that was an hour long and we could approve it, but that wouldn't be a very good.
And I would be speaking to you about that.
For level 1. That's probably why you and Mr. Roberts had that conversation. And I think Keith has probably been around the longest far as the board members are concerned. Do you remember that?
I don't have it. I would say that was even before me.
Yeah, I was going to say, that might even been before me, because I don't remember it either.
I know that since I've been here, there was one class that was presented that almost got through without like a proctored exam or something.
Yeah,
I mean, sometimes, they get submitted and they're checking off every box, and we're looking at them really more for continuing education,
Right,
and
then
then all of a sudden
initial.
it's like, oh, well, wait a second, this was initial application, this is a different animal. And I think we've looked a little closer on when some people had either, some of the video proctor and some of the different proctored exams. Some of them are doing an online and then they go to a class, take a test. But I think we might have had some that almost got through like that. I don't know if there's been one more recently. Was that one a long time ago, or was that
Yes,
something?
sir. That's one of the things that we would like updated, is instead of saying level 1 or whatever, we would like just to
Level
put in
one
a
and more.
definition of the training equivalent course needs to incorporate these things.
So as something for rules would be good to
Yeah,
define.
that's what I'm saying. If
define
they
that,
would
yes, ma'am.
do- That would be a big help to us if the association would take a lead in doing that.
We're talking about defining equivalent training?
Yeah, yes.
Okay.
Honestly,
Minimum hours, right? Minimum
Right.
hours, proctored exam. Yeah.
Ethics
Yeah,
maybe.
We need to
Be
take
nice.
a look at the proctor exams again, too. I mean, there's a lot of colleges or other places you go that are not proctored like you're saying is being proctored. That's really been a topic of conversation with this program before. But yes, please work with me. I'd be glad to see any paperwork. I'd be glad to present anything to the board, but it needs to be done through me so I can actually present it to the board, so the board members weren't give their personal opinion.
Sure. Yes, ma'am.
Thank you.
I think our next are the administrative matters.
Yes, ma'am, I just got a few things. If you want to turn to the monthly report, I just looked at September, just talks about our alarm meeting with the attorneys that I had, the physical meeting, and the number of complaints. That's just standard that we do every board meeting. I'm going to do something for the next one is the budget. I'm going to have Shauna throw something up on the wall here, but please bear in mind that this is not the final. We are still working. I told you earlier we were trying to do a graft of the states. We had to determine if we're too high, we're too low. We are in the middle range for the fees. We can see that. I'm still having some difficulty finding out how many they have versus how many we have. I do know our registered employees are higher, the second highest in the country. Second highest that we have been able to obtain information on. So if you give us a second here, we'll go ahead and look at the budget while she's getting that together. Of course, you ended last year in the black. That was great. You do have, hopefully, the one for July and the one for August. That leaves you right now with a balance of $22,900. Every year, I tell you, as we start July the 1st, we have to start with a zero balance, and then we have to end in a positive next year in June. So your time goes from July this year to June of next year. And I might have looked at it wrong down here, but if you look down, you have the historic trends. You have 18, 17, and 16. What I don't have is 16 expenditures. Still have a $500,000 reserve. We talked about the reserves. I'm not able to get into the reserves. I have joked numerous times about the printer, but that's where it would come from, that we would need necessary changes. You got that, Shauna? Let me put that down so I can see it. Give you a little idea there. Across the board, it says the alarm board, initial cost and renewal cost. As you can, I'm going to have to look at it because I'm not going to be able to see it either. That's all right, I'll do it from up here. From what we could see, Alabama does not register employees or qualifying agents. They just do the companies. 636. Now, if you know information that I don't have, now it's the time to tell me, so I have to go back to
Okay,
these states and look.
If they charge $50 for registered employees, do they not have any, or, I mean,
That's one of those that we have not been able to get any totals on. Remember, we have requested by telephone, by email, and by public record some information from different states that we have not gotten. I am going to go to the International Association of Regulatory Body, the ISR board. These are the directors of different states, and see if I can get them to help me get into the right department to determine what's going on.
I think
so
Alabama,
what you're saying is they have 636 companies.
That's
and
what
you-
they told us. They did not tell us. We haven't been able to determine how many registered employers or qualifying agents they have.
I believe they do register employees, though.
Okay.
I know,
Do we have that chart further down?
because if a company is 100 miles from the border or something, they don't have to be
We have
registered.
Alabama then.
Because I can tell you from personal experience, they
They do have.
can't
Good.
decide whether Memphis is 100 miles from Alabama or not. 1 year it is, and 1 year it isn't.
Okay.
Google.
We need to make a note of that. How many, never mind, we'll go back. Push on back, go back up. Okay, now let's take the next one. Arkansas, we were able to get some information from them. Registered employees, 3,164. Qualifying agents, 412. Companies, 412. Then it went into, is $75 for a registered employee. It's hard for me to read that as well. Qualifying agents, 35, and the company is 600. Like I said, this is not the final to go by. I'm not going to even look at the renewal. Let's go to Georgia. They got 947 registered employees that we could tell. We still don't know how many qualifying agents or companies that they have, and no fees. We try to do surrounding states. That's usually what they want to look at, because I don't want to go to the Hill and have a discussion about the alarm board and their fees and the number of employees, and then have a discussion of, we found out there was X number of employees. Ms. Bass, how come you didn't know that kind of thing? We want to make sure our information is correct, best of our knowledge. But this is what we've gotten so far. I wasn't really going to present this today, but I just wanted you to see. Look at Tennessee, we got 6,828 registered employees, 780 qualifying agents, 646 companies. These are active, of course. Every one of these registered employees must have a ID card and must have their photos on it. They must have a background check. We take that in consideration when we look at the other states as well. The registered employees, $100. A little bit more than the other states there. Qualifying agents, $200, a little bit more than what the information that I have, and then the company's going to fall right in the middle bracket there. You can see with this, some of this information in gray is telling you what we were not able to get from the other states so far.
I don't know about some of those, but I know Mississippi and Virginia have, they didn't respond, but they do have licensing. But Mississippi it's through the Mississippi State Fire Marshal's office, even for the
Right,
burglar
it's
alarm.
different. They don't have an alarm board like we do, right.
They don't have a board.
Some of
but-
them are county, like you used to be. You used to go to the county and get yours. Well, that information is what we don't have. Because we'd have to go out to every county in that state and see how many they have.
Mississippi has state licensing.
Okay, well, we'll try to do
does.
that some more.
Kentucky doesn't. Now, the certain, like Louisville has one.
Right.
But
All right, I think we put, that's what it is, by certain jurisdictions. It just depends on where you're at, I suppose, on that. Come down, can you come down with that, Dre? That just gives you an idea there. Arkansas's got 3,164 compared to our 68, so I'm sure there's other states out there that do regulate employees.
Well, you were talking, one of the things is about the fees. Now, one of the things that we do, I was actually thinking about that as I was driving over, as a monitoring center in Utah. By law, they're supposed to register their employees, even though we have no jurisdiction out there. Nothing we can do if they don't. Now, we can ask for the monitoring center to become registered. In a way to reduce fees, a monitoring center typically has no pertinent information, or at least our monitoring center. They don't have, they got the customer's name, address, and phone number. That's all they really have.
That's not actually what we have been told is why, yes, sir, I know what direction you're going in there.
Instead of going.
We've always been
registering
told the monitoring company does have access to know how you turn your system on and off. That person's sitting there,
Zone list.
that's why they're registered.
Password zone list, but
They've also got, that person there has the ability to not respond or to ignore an alarm.
I agree, yes, but I'm thinking of how they're going to harm the end user. So we've had it since I've been on the board, they had this background, and basically they get approved because we really have no say-so who's in Utah. And I'm just using Utah just because that's where one of them is.
But we do look at their background, and we do deny people's applications based on their background. We may make exceptions and allow somebody in the industry.
But if I'm a business owner in Utah, Tennessee can't do anything to me. I'm not saying they do. I'm just saying
You have to
that
be licensed through the Secretary of State. They can revoke your license.
that's the business.
It's true, but if you can't operate in Tennessee, then
Well, let me just say, for instance, now I know what direction, I kind of feel like we know what direction you're going into. A registered employee gets a card that says he's a registered employee. It doesn't say, I work as a monitor at a monitoring company, or I'm at a fire, I'm at Berg. So there's no way for me to divide that 6,000 and say, you're monitoring employees.
Yeah. And I'm
Unless I
be
go
willing
to
to
the
bet on
company.
a lot of that is
That is,
monitoring
and
center
I would
people.
dare say that's probably your bread and butter right there.
Well, there's also probably companies that are
That's
monitoring.
that classification.
Well, there's companies that are monitoring companies and have one registered employee. That should be a red flag for an investigator to find out why, because one person cannot run a monitoring center. No. It's not possible.
Two people can't run a monitoring.
It takes 4.5 to monitor it, one person around the clock. For a week, it takes 4
Okay.
people.
I was not aware of that either. How many people it takes. But yes, that's what we're looking
me
at. We're
ask
looking
you
at
this.
ways to do this.
okay, like you say, you have people that are under the registered employee classification that works in a monitoring center. Would that not be on the application, and then got installers that are registered employees, and you've got monitors that we distinguish between them and reduce cost on the monitoring employees?
The only classifications we have is on the company and on the qualifying agent.
And I think what she's asking is, can you add that for registered employees? That
Why can't
Would that
you
take a
break
law
it
change?
down into registered employee?
administratively, can you basically add that classification to?
But really, if we're
Well,
doing a
nobody do
background
that.
check and we're going through we're issuing a card and doing everything else, the fee should be based on that, what that cost is. We shouldn't charge less for one classification than another for the employee's card. I mean, that fee's supposed to cover the cost of the background check and making the card and the overhead administration.
That's the way it was previously, yes. Now, the background checks, we don't do those background checks ourselves anymore. They have to go somewhere else to have those done. They go someplace else to have the test. They don't do that through us.
Who pays for
so
the
we
background
need-
check? I know as a business owner, I pay you $100 for a registered employee.
For registered employee, but that's not for the background check, because they have to go to someplace else to get.
Well, we go and get your
Applicant has to
fingerprints.
But that doesn't do, all I gets to report.
The applicant pays.
The applicant, yeah, well, the company does, because the applicant works for the company. You won't send me the application for the registered employee, but you still have to send your employee someplace else to get a background check.
He
Be
gets his
fingerprinted, I should say.
Fingerprinted.
And then
Fingerprinted.
then the report comes to us, and then that's where I have to have the employees to be able to sit down and take it. And there's a whole lot of registered employees there and there's 3 people that do nothing but those background checks.
So the fingerprinting, are they the ones doing the background checks? Or they're just sending you the fingerprints?
The employee is printed, it's electronically sent to the TBI and the FBI, and then we go into the TBI system and pull out that information.
We
We
don't-
manually have to do that, yes.
So your personnel are.
Does it, right.
So so part of the fee covers the cost of.
For us to
the
do,
labor.
part of that $100 is for us to look at those background checks,
okay.
look at you only see the criminal records
Your problem.
that we cannot make decisions on. We see a lot of criminal records. But you're not going to see them because we can look at the statute and it tells us what we can do and make a decision on that. A DUI is, we say, a normal driving offense. We very seldom look at one DUI unless it was something else that happened. But if we see a pattern there, I'm going to deny that application, or I'm going to take it now to the Fresh Start Act. That's something else my employees have to do now, is look at the Fresh Start Act on every application that we're going to deny. What I was talking about, is there a way to reduce the fee on producing the card? The work still has to be done to do that.
On the replacement card, like.
Like I was talking about the transfer. If I look at there's a transfer, this means a form comes in and says, I've left company A and I've left company B. We just go into company A, say I'm no longer there, hit delete and you're gone. We have to go over to company B, and that's where we actually take a few minutes to have to put the information in. It's not like it used to be. And we have, with the system that we have now, if we have a company that purchases another company, and let's say they have 100 employees, we have to transfer all those employees over to that company. But now, as you know, every employee works for a company. When we push that button, the computer system now automatically puts in every registered employee now changes that address. We did that manually for years.
But when they
Data
change
entry.
companies, you still have to reissue.
You issue a
cards.
card, but we don't have to do like we do on the initial application. It takes longer for us to get the initial application. We have to actually do more work to issue the card. The transfer, we can do it very quickly.
Computer system
Has helped
made it
us there.
Data entry.
Shauna, scroll it back up to the, yeah.
That's, the attorney was asking me if I had those figures on the transfers. We don't yet. I'm working on that. Like I said, this is just this preliminary we were doing.
Can you do a cost analysis on the time and?
That's what we're doing, yes.
That's what, I mean, I know you're doing the survey on the surrounding states, but I think there should be some way for you to do a cost analysis on what, from the time that application, you have your first or hands on that application till the time that card is printed, you should have a cost analysis on the amount of time, the card creation, everything, to show, and put the benefits in on the employee's time and everything else to show the justification, and then see how far off you are.
Yes, we are doing that, Madam Chair. That's what we're trying to do. And I'm also trying to determine what is the actual cost of producing a card. We're not the only ones that do that. Once I push a button, the card is actually printed off-site and sent over here. So I have to figure out how long that has taken. It comes into the building, hits another floor. There's other personnel that touches that card with their reports. How long does that take, even before we get their card? So I have to take all that in consideration, and that is what we're trying to do. But I was trying to, with this, I'm trying to get you some information I can actually take to the Hill when they say, well, Ms. Vest, you're charging too much according to the other states. I want to be able to say, well, I did this study, and Alabama does this, Kentucky does this, that one does that. So this is where we've started. It's just going to take a while, and hopefully I can get some more information together that I can intelligently send it up, take it up with us if and when we have to go in December.
You also need to find out from these other states what their process is. They may not even require a background check. They may have a stick-on name tag that says, or a pin-on name tag that's not state-generated. These are factors that need to be explored as to, are we comparing apples to apples, or is their systems apples to oranges? Is the reason their cost is less than what Tennessee is?
Yes, we ran into that a good bit also. Some of them, from what I understand from my staff, it's hard to say because they don't do the classifications like we do, or this classification stuck in with this, and we ran into some little bit more difficulty than you think we would have, just to say how many employees do you have, what do you do to do you do a background check? That should be, well, to me that should be out on the internet, and when you go to look at an application for a company like ours, here are all your requirements. We hadn't been able to obtain all that information yet, but I'm working on it.
Would it help any to obtain just their budget information, to have their revenue and expenses, to at least compare that? Would that be something that?
She said I could make a request for that. I don't know if they would give that to me or not.
That might summarize it more so. I mean, it.
Well, another thing too is if you're not you would only be getting one part of the process, but alarm companies, and I'm going to use Kentucky for example because you've not gotten anything back from them. Call an alarm company in Kentucky and have the owner explain to you what process they do or don't have, so you would at least have an idea as to, well, we don't have registered employees, but I as a company pay $1,000 a year, so then that would give you step B to go to find out. Reach out to individual companies, and it's not going to give you the whole state, but it's going to give you an idea on where to go. If they are paying for registered employees initially or renewal, then go to the state for that money or that dollar amount.
That's an idea as well. I'm going to be kind of limited there time-wise, but yes, I need to, if I want to say Alabama does regulate their employees, companies, and qualifying agents, I need to know that they do it the same way we do it. Or it's the same way that we do it anyway. Or we have the same requirements.
A legitimate alarm business owner should be able to tell you ABC. Go ahead. Or, hey, you've got the state chapters.
Association have that information?
Alabama and Mississippi have much harder regulations than we do. They regulate.
Oh, thank you.
Amounts.
I forgot I couldn't see him behind Ashland.
So that's why we need to be working together.
I wouldn't know the exact numbers that they have registered in the state, but I can definitely tell you how much.
But they could also tell you where they send that. If they are sending applications and funds in, they may have a contact person or something that would assist.
You do have my email address and telephone number. Okay, we'll be working, yes, working with the association. Yeah, you didn't realize that, did you?
Why don't you add Florida and South Carolina? I know that's 2 more states up there. You've got Missouri on there. You know, that way you've pretty much covered the southeastern coordinate without going over into.
Does anybody have a Florida license?
Attempted once.
Do you know how, it's not real easy to get a Florida
I have
license.
an instructor license.
Okay.
Florida and
But
Texas
still,
are
you're
both
showing
very-
a region instead
Yeah,
of
that's what we want to do,
get South
surrounding.
Carolina and
You don't want
Florida.
South Carolina. It's wild, wild west.
And you're showing that region
easy.
for comparison.
We're going to trying to hit all of the states that surround us, because when we go up to the hill, I want to be able to say, yes, sir, we looked at the map and we did this. It's what we want to do. But I say, this is what we got started. At least we got this part done, or started to do. It's not exactly finished or anything. Isn't there something underneath that?
Oh, and North Carolina goes through the electrical contractors board.
Yes, I mean, there's a
They
lot.
go through
There's.
the electrical,
It's not like I'm
the
just going to
alarm.
get on the phone and call
You got to get your
electrical.
electrical, then you apply to the alarm
Yeah,
system.
so you got to go through two.
But then, you know,
Well, see, that
so how
needs to
much?
be included in there,
you
that's
know.
even more complex than what we make them do, that, you know, you've got 2 hoops instead of 1.
At the end of that one? What's he got down here, original data?
I didn't understand what that was.
Oh, this is just more information, like, see, there, it says Arkansas, the state police, this is who we've tried to contact through. The next one down there says call state office, they don't have numbers for total number of employees. Why wouldn't your state office have this? Well, I don't know, but the other one is a low voltage, and all they have is an exam. Exam fees 90, multiple, so, yes, we made some notations out to the side there, I knew that was there. But it's not very much information there. I've had to do the same thing for private investigators, because they're the ones that are in the red. For some reason was a whole lot easier, I guess, because it's one classification. It's just a PI. This is just a little bit more in depth, and we're going to have to get a lot more in depth. And it's really hard to sit there and break it out to those 4 categories. Yes, Keith? Arlington companies will? Okay, there you go. Can you make that note, John? We're taking notes here. This is great. I should have started with you to begin with.
Hey, you talk.
Then other than going out here and trying to do this. But that's okay. I just want, I'll try to get more information on this and try to get a better graft on it as well. Like I said, we really put our emphasis on the PI program because it's the one that's in the red. Now that we have to go to the Hill, because she's in the black, they're going to probably ask me this information. I want to be able to at least give some intelligent data anyway. Oh, yes, we'll move on down if you don't have any more questions or any questions about that, and I don't have any legislative update. We don't have a request for an extension, and we don't have any criminal history reviews. Doesn't mean you hadn't had any, but there's none for you to review, you know. Okay, we'll go right into the education report. We only had just one submission, but it was 2 courses, and we did send that out to Scott. Scott, you want to tell us what you looked at?
Sure. This is another one that says initial app, which it definitely wouldn't be good for initial app. It would be good for continuing. They checked it off, but they didn't, in their letter, they weren't actually asking for that, I don't believe, when they
Okay, then they did ask for Berg and CCTV, that's all they've marked. And what you're saying is that's okay, but we're gonna put it,
That's not it. You have the other one you were supposed to approve.
which one? Okay, which one did you have there, Scott? Electrical license renewal.com, I believe, is who sent these in.
Right, it's installing code compliant security systems, part 1 and part 2.
So they did ask for initial application and continuing education. You're saying continuing education.
Right.
And they still marked it for Berg and CCTV.
And monitoring.
Which continuing education, we
Okay.
don't differentiate.
Yeah.
My only concern was if this online class is 4 hours, they have screenshots of all of the course material. I didn't do the online, they've got an online login. I did not go online. Are you saying like what's printed, all these slide shots are just part of it?
Yes, sir, because they gave you the wrong password.
Okay.
We found out what the correct password is. But we're able to print out what the course objectives are. And then you do have the screenshots of the main menu.
They've got 5 minutes per slide on here. I believe it's like 50. I don't know if this is slides or section. They say section, but I don't know if that's individual slides. That's my only question, is if it's really 4 hours worth of content. Does anybody have any opinion on that, looking at it?
Slides, I mean, you can, like this class 1, class 2, class 3 on this course, it's going to take.
Sometimes we get this information, it's just too much to print. We look at. But what you're saying is you don't think it's a full 4 hours?
Well, it's 2 4-hour classes is what they have submitted, a part 1 and part 2. A lot of it, I mean, it is electrical related. It does apply to the industry. A lot of it is stuff that doesn't necessarily directly apply. They have addressed a lot of low voltage items. The person that teaches the course or designed the course is an electrical codes instructor and an electrical inspections. He had been in electrical inspections person. I'm comfortable with the classes and that there's enough that applies. And for continuing education, it might borderline, but I feel like there's enough there for what they're asking. Unless anyone else has any objection.
So some of these slides it looks like there's some that were skipped or missed, so I'm not sure if you're seeing, like, see here? Yep. Well, could it be, yeah, so there's probably more
I see what
slides
you're
than what
saying.
you're actually seeing.
Go up to 50, and then if you look at his list, there's,
So
List of 50 at 5 minutes apiece. Do they correspond to this list?
Yeah.
I think it's a bit of a stretch for 5 minutes for one slide, one.
So, what are we saying here about both of these courses? Are you looking at both of them for the same?
So each class is 4 hours, and there's 50 in. Is it in each one? I'll make a motion to approve as it presented with 4 hours each with just for continuing education, but not initial application. Both courses, right?
Okay, we have a motion by Mr. Cockcroft to approve these two courses, Part 1 and Part 2, for installing code compliant security systems for continuing education only. Do we have a second?
Second.
And a second by Mr. Richard. All in favor, voice by saying aye.
Aye.
All opposed? The courses are approved.
All right, we can move on. I don't have any unfinished business, but we do have some new business. And that is your 2020 schedule. If you noticed on this particular schedule, sometimes the rooms change. We're in the big room versus the small room here. The other programs have already gone out and got their dates as well. Like February's in 1B and April's going to be in 1A. We'll
That's
move
just
them.
that room
That's right
versus
there.
this one, yeah.
That's all it is.
Get
A whole
lost.
lot bigger rooms, all it is. And I believe that is all I have, Madam Chair.
Anybody else got any old, new, unfinished business? What did we decide about December? Are we canceling the meeting, or are we not, or?
I think that's up to the board here. I just made that suggestion.
Yeah, I mean, I don't know how much.
Because I didn't want to bring you in both times. One's 1 week, one's the next, but now I don't.
Or, I mean, I believe, let me pull up the schedule. Typically, sunset is usually at 1 p.m., so I don't know if a room's available to move the meeting from the 11th to the 18th, and then we do the meeting that morning and then go to the Hill that afternoon. I don't know how the board feels about that, if that's too much. But I was just thinking, trying to avoid
Coming in twice.
coming in.
As long as we're able to find a room, yes, that we can televise, yes.
It looks like actually sunset would be at 9, so we could do 9 and then the lively sunset will be.
Or how, you don't know how long it's going to take.
Exactly.
You
Or
could
we
find
will
out
end up
by
on the
2 o'clock
agenda.
in the afternoon or something, I don't know. That's going to be.
Yeah.
Not anybody else, but I'll probably be already stressed out enough just doing that to have a board meeting.
18th.
Keith can tell you, and Vivian's been there. Sometime
You could last on the agenda. and you're
it
sitting
could
there.
be. They could just,
Hours.
yes, and do absolutely nothing.
And the thing is, you're sitting out depending on which room we go into, you're sitting out in a hallway. Not a tiny hallway, but just a hallway until you get called in.
Right now, they have moved over to the Cordell Hall building. This is right up the street.
Sort of an auditorium-like thing.
Right, that's it, But that's changed as well with the new room. They've got some a nice
Where's
facility.
the Cordell Hall building?
You just walk up
Just
Fifth
looking at-
Avenue, it's the first building on the right you come to.
Just
Right across
yeah.
from the auditorium on Gay Street.
Room 1A is not available.
Okay.
Hold on just a second, we're checking room availability.
That backs up when you hold them that long.
So the 20th is not going to be, not going to work.
Saturday, isn't it?
No, it's a Friday.
It'll be on Friday.
Oh, so the sunset's on Wednesday?
Wednesday, December 18th is the tentative date, yes.
That's the week right before Christmas, so.
Rooms are going to be,
Well, we can try it on the 18th and set it up as long as we're here on the 18th, and we can come back down here, and if nothing else, if we have a whole
Go
lot
to
of
a conference
continuing that, all depends what time frame that we have. Fine. I don't really want to go to another conference room because it's not recorded. Or recorded and
I
live.
think I can get it on the 18th.
How about that then? We can attempt that.
So move the board meeting a week from
Move the
11th.
board meeting, yes, up to the 18th. We'll all meet, we'll go to the Hill, because you're going to be here anyway, lunch, whatever. We'll come back down here and we'll have our board meeting.
Problem is if we have appearances or anything, when,
Well, we just have to notice them. And
I'll just have to tell them, you need to be here at 1 o'clock and you might be sitting here at 3 o'clock before you're heard.
Right.
I mean, I don't know.
Appear that day.
You know?
Be here that morning to go to the Hill.
I beg your pardon.
What time should we be here that morning?
Well, it starts at 9, so we'll have to be
Well,
up here,
well, we
be there at least a
know-
quarter till.
yeah, but do
We'll
they put,
notify you the room number, room and everything. Okay.
Are we going to meet here and go up there as a group, or just up there?
Typically, that's what happens. The legislative team will tell us to meet here, and we usually walk up there together because, I mean, it's still downtown parking. Like I said, it's.
Okay. Do they have, granted, we won't know the hour that we're, but do they not have a schedule for the 18th?
The closer it gets, they will publish an agenda, and we'll kind of know where we appear on the agenda.
Then they can let us know, Keith, what time we have to be here, instead of being here at 8:30 and our appearance is not till 11 or whatever.
Well,
we
even then,
still
I don't
have
think
to
they
be
put.
there.
I don't think they put a time on the agenda. It says 9 o'clock is the start of the sunset hearing, and then they will just list 1, 2, 3, 4, whatever departments or boards are appearing, and you're there, and they just go through the agenda.
And usually it's alphabetical, and we start A.
Commerce. Then we're C.
Stop that. Okay, we got the room. We got that locked in anyway, so now you need to make your arrangements.
It would just be in the other room.
And that's for the 18th of December? Okay. All right. If there's no more business to discuss, this meeting is adjourned. Thank you.